Call this meeting of Judiciary Committee to order. Members, take your seats. Chair recognizes a quorum. We've got 2 bills up this morning and 2 bills up tonight. This morning is the distracted driving bill, House File 50, and then private cooperative divorce. That's mine, 1115. Tonight we'll have the 2 gun bills. First item is approval of minutes from March 1st. Do I have a motion? March 5th. Do I have a motion? Representative Cantrell moves the minutes of March 5th. Any discussion? Seeing none, all in favor say aye. Aye. All opposed say no. Motion passes. Minutes of March 5th are approved. The first bill up, Representative Hornstein, House File 50. I move that Representative Hornstein's bill, House File 50, be recommended to be re-referred to the Ways and Means Committee. So, Representative Hornstein, welcome to the committee. And we have an A8 amendment. Is that right, Representative Hornstein?
Correct, Mr. Chair.
Did you have someone set up to offer this, or?
No,
I'll offer it.
But I was hoping.
I'll offer it. So does everyone have a copy of the amendment? Everyone good on it? Any discussion? All in favor of the A8 amendment, say aye. Aye. All opposed say no. Motion passes. To your bill as amended.
Thank you very much, Mr. Chair and members. I really appreciate your hearing House File 50. I understand that it's the committee's preference or the chair's preference to keep our discussion limited to the item that relates to this committee. I can just go very quickly over the bill in general, Mr. Chair, but again, I want to limit it to the jurisdiction. But members, this House File 50 is known as the hands-free bill. It is an effort to address the growing epidemic of distracted driving in our state. We have averaged 53 deaths on our roads over the last 8 years due to distracted driving and over 200 injuries. This legislation has been enacted in 18 states, including the District of Columbia, and in most of those states, traffic fatalities have gone down and have gone down in some cases dramatically. So we know this works. We know that many people across the state are very concerned about this issue, and that is the urgency of passing this bill. We have received a lot of widespread support, including from the business community, the traffic safety community, many of the families who have had loved ones perish in distracted driving crashes have been particularly active and particularly effective advocates. Some are here today. Although they have testified in earlier committees, again, we will restrict our testimony to the issue at hand, which I wanted to get to, Mr. Chairman, quickly. When this bill came before the Public Safety Committee, some issues were raised ahead of the hearing. There was some concern given the possible increase in traffic stops that may accrue from this bill once it's passed, that there might be the need for a study of traffic stops so that we could ensure that profiling would not increase as a result of this bill. So at Public Safety, we added an amendment that called for a traffic stop study. And in that amendment, there was a very, very limited study that was to be conducted by the State Patrol. A number of important concerns were raised in that committee, and I have attempted to address all of those concerns in this new amendment that was adopted today. So, Mr. Chair, if there aren't any questions about the body of the bill, I want to maybe get to the amendment, the data piece, and the study.
Go ahead, Representative Hornstein.
Okay, thank you, Mr. Chair. In our new amendment that was adopted, the A8, I have addressed I think almost all of the concerns that were raised in the Public Safety Committee. Rather than the Department of Public Safety conducting a limited study of traffic stops that would involve active involvement by individual state patrol officers in terms of collecting demographic data as they are giving citations, that has been dropped altogether. We are aware of concerns about the department conducting a study of this nature. And so the first thing we do in the A8 amendment is to appropriate money so that an independent third party would conduct the study based on traditional and rigorous social science established standards. And in the process of researching this type of study, Mr. Chair and members, I realized that the legislature in 2001, on a bipartisan basis, had asked for this type of study. And so what the amendment does is simply ask for an update of this study. And we have had several significant things happen since the legislature on a bipartisan basis. Again, this was when Speaker Svigum was heading the House at that time. We have had several, in addition to concerns related to what the impact of the hands-free bill might be on traffic stops. Since that time, we have enacted the .08 alcohol standard. We have done primary seatbelt, and we have had the texting ban. And then we have potentially then this legislation. So that's in case you're following along your Minnesota statute book, that's what Section B and the adoption of those statutes 1, 2, 3, 4 indicate. And finally, Mr. Chair and members, this is a completely voluntary effort on the part of law enforcement. We are looking at existing data. We are not asking law enforcement at this time to collect new data. That is a very, very important change from the last version of this. This is just simply going to be a major research project conducted by an academic or other institution chosen by the Department of Public Safety. And then we, of course, have a report to the legislature. In sum, Mr. Chair and members, this is a much, much better way to get accurate data related to traffic stops in the state, and it simply updates something the legislature has already asked for previously.
Excellent. Thank you. Now, did you want to do questions, or let's go to?
Well, I do have one testifier, Mr. Chair.
Is it Professor Orfield, or is it former Representative Orfield, or is you probably have a few other titles, right?
I'm getting fewer.
All right.
Should I?
Yeah, well, I just want to introduce the testifier, if that's okay, and what he would talk
Absolutely.
about.
Go ahead.
So Professor Orfield, of course, is a former colleague. I think no one currently here, I think, served with him around the table, but I know Representative Mariani was in the legislature when Representative Orfield served. But as
I was an intern here.
You were an intern, okay.
Orfield.
So you're familiar with his work. But, Mr. Chair, when I was researching if a study like this had been done in Minnesota, I learned that Representative Orfield was one of the people who had conducted the earlier study. And so he can really talk a little about what we're addressing here, and specifically with the data collection and the data gathering piece. So he will confine his comments to that.
Yeah.
Thank you, Mr. Chair.
Welcome to the committee,
Thank you,
Professor Orfield.
Thank you, Mr. Chair. My name is Myron Orfield. I'm the Earl R. Larson Professor of Civil Rights and Civil Liberties at the University of Minnesota Law School. And I worked on the 2001 study that was passed by the legislature. It was after I had left the legislature and was teaching full-time at the law school. And it covered 65 police jurisdictions in Minnesota. We had very good cooperation from all those jurisdictions. We produced detailed reports about the police profiling. It was, I think it led to a number of significant reforms and was broadly accepted in the law enforcement community at the time. It's on the web. You can take a look at it. It's 16 years old. Representative Hornstein asked me if we or another qualified research institution could recreate that study, and I think our organization, or probably many other qualified organizations, could recreate that study and follow up on the 2003 study.
Excellent. Thank you. You stand for questions then?
Sure, absolutely.
Questions for Professor Orfield or the author? Chair Johnson.
Chair Lesch, Representative Hornstein, Professor. I understand the study, which might probably be a good thing since we haven't had one for so long, especially dealing with all the other issues. Representative Hornstein, we had a conversation after the public safety hearing, and I think we agreed where the demographics were going to go for the citations. But a lot of people don't realize the average age of a vehicle in Minnesota is 12 years old. The Bluetooth technology and the technology to do the one-touch has only been around with about 75% of the cars starting in 2014, and up to today was being put in the cars. In fact, as of right now, only 86% of the vehicles in production where it's Bluetooth capability or sync or whatever are produced. Not even 100% of the cars have that capability. Now, I understand the situation with the past testifiers and the people in the audience, and I feel real bad. I had to go to those crashes, and I've had to knock on their doors to tell them their loved ones weren't coming home. But the concern I have is this bill, I believe, is very discriminatory. Because who's going to get the citations? Because they don't have the capability to have Bluetooth or one-touch. It's a middle to low income. I can tell that now because over 70% of the cars in Minnesota do not have that capability. And when you get outside the metro area, a lot of places don't have LTE. Without LTE, Siri doesn't work. Your one-touch on your phone doesn't work. Unless you have a vehicle that's Bluetooth capable, then it'll work. Now, where will most of these citations be coming from? Low-income areas in the metro area. Most of greater Minnesota because one-touch doesn't work. Who gets the advantage of this stuff? The rich, the wealthy, because they have vehicles that actually it works. Yes, do we need to do something? Absolutely. We need to stop texting and driving. The State Patrol and the law enforcement across the state have learned what to do and how to pick up when people are texting and driving, and citations are up. Not because more people are doing it, because they've learned how to adapt and how to catch drivers doing it. Now, last year in my omnibus bill in public safety, we linked texting and driving with vehicular criminal operation. This bill doesn't do that. So even if you're in a crash and seriously injure somebody, it's still not a crime because it's a petty misdemeanor. That's in all the testimony we heard last year and even this year. We've heard people complaining because the penalty for what they did wasn't enough. This doesn't take care of it.
Thank you. Thank you for your comments, Chair Johnson. Other comments regarding the study proposal. Representative O'Neill.
Thank you, Mr. Chair. I just wanted to thank you, Representative Hornstein, because those were legitimate concerns, and I know particularly in public safety, we're trying to. We've been talking a lot about race. We've been talking a lot about gender in this particular committee as well. And I think that in light of those conversations, that study had a whole different meaning, I think, than was intended. So I really appreciate you taking that out so that we can move this bill forward and actually protect folks on the roads. Thank you.
Other comments? Representative Grousel.
Thank you, Mr. Chair. Thank you, Representative, for the adjustments you made, because in talking to State Patrol during and after that last session, there's a lot of concerns raised by the people on the road and the union. They had a lot of concerns as to, are we going to be used to start to profile people, and it was so there was very legitimate concerns from the boots on the ground, and they didn't want to have any part of that. So thank you for making the adjustments that you did.
Thank you, Representative Hornstein. It's no secret that I've always been very adverse to more reasons to stop people. I was one of the outliers on the primary seatbelt bill in 2007 or whenever it was we passed that. I did not want another PC reason to stop folks, because it always ends up being people of color who get stopped. And when I say that, what's important to me is that a lot of times white people or white cops take it personally because they say you're accusing us of racism, stopping people because they're people of color. That's not what it's about. For me, racism is structural. It happens throughout a system. And that means that it pervades a system or a group independent of anyone's personal prejudices or whatever. You see it in shoot, don't shoot studies. White cops, black cops have the same numbers. That means it's structural. And that means we shouldn't be blaming any one race or any one group on the effects. We're all accountable for it, the entire group. That's why it's my hope, despite my general aversion to studies, it's my hope that this can move us in that direction. The study piece can, because I think this is a group effort to solve this. This is not any one group that gets blamed for what's going on. We all own it, and that means we all got to solve it. So that's all I'll say about that. Any other comments from members of the committee regarding the amendment in the study? Okay, seeing none, then the motion is that House File 50 be recommended to be re-referred as amended to the Ways and Means Committee. All in favor signify by saying aye. Aye. All opposed say no. Motion passes. Thank you very much, and
Thank you very much, Mr. Chair and members.
Okay. Okay. It's in there. It's on their spreadsheet.
So I think your point might be moot because I think they just talking on the phone.
Because I,
Did you see that? Read that. Phone call. Surprised he didn't just say that.
get it. So it's either we want to correct it or ask if we want to
Gee, you understand this place really well.
But that's neither here nor there, and motion's passed.
So number one is
Really?
any kind of cell phone call. Initiating or talking.
All right, members. The next bill we have up is House File 1115, the Cooperative Divorce Program. Chair Lesch, would you like to move your bill to get it before the committee?
I would, Madam Chair.
All right, Representative Lesch will move his bill to be recommended to be re-referred to Ways and Means. And if you want to go ahead, Chair Lesch, and tell us about your bill, please.
Thanks. I would, and I'd ask I don't know who my first testifier is. Come on up. Madam Chair, last night we had a big deal family law bill, and I've always been generally adverse to carrying family law bills, and yet I seem to end up carrying them. Family law is an ugly business, and it's very personal for me because I went through divorce in 2004, 2005. And it was a horrible experience, the worst experience of my life. And I went to Ranger School, and I've gone 4 days without eating, and I've done a lot of tough stuff. But hands down, that was the worst experience of my life. And part of it was because the way the system is set up. My ex and I, after a grueling process of a long time, had come to the conclusion of what we were going to do and how we were going to handle custody and child support and all that business. And as difficult as it was, we got the conclusion anyway. And I told my wife, okay, well, go to a lawyer. And I was so dejected at this time. I was beside myself, unable to even to think clearly about anything. But I said, take it to a lawyer and, get it memorialized and, I didn't know the phrasing of it then, but it was stipulation. We'll do a stipulation and get it signed off on and sent to a judge. Well, a few weeks later, I get this scud in my mailbox, which is you're going to owe $1,700 a month child support. You're going to get your see your kid one weekend every 2 weeks, and all this blah 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 blah. And I called my wife at the time, and I said, "What the hell is this? What happened to our agreement?" And she said to me, "Well, I talked to the lawyer, and the lawyer said I only represent you, and I don't represent him," which is true, right?
I think they thought you said.
Anyway, and which was true, and she said, "Well, you're just trying to get out of paying child support, and you're trying to take my kid from me." And I thought, well, that wasn't our agreement. I'm not trying to do that at all. We're trying to cooperate on this. But the system is set up whereby family law attorneys, and I've practiced family law. It is the principle that if the only tool you have is a hammer, every problem looks like a nail. And there is this constant pounding and pounding and pounding on various nails, and the family loses in the long term on that. And everyone has a different story about it. Mine was horrible, and we ended up that she and I so I ended up having to lawyer up also. She ended up spending 4 or 5 times what she should have. I ended up spending probably 2 or 3 times what I should have had to, tens of thousands of dollars more than was necessary. And at the end, the ultimate stipulation was the same thing that we had agreed on originally. The same thing. And I was very frustrated with that. And we were able to get to the point where we have jointly raised, my daughter's 18 now, and we jointly raised her for, the past 16 years successfully. But it was in spite of the current family law system, not because of it. It was completely in spite of everything that it encouraged us to do. It encouraged us to hate each other, to develop vitriolic animosity with each other. And I had to bite my tongue in half several times in order to make sure we could successfully raise our kid jointly. It was really hard. And I also would add, I know there are plenty of reasons that there are individuals out there who could take advantage of their partner. That could happen, okay? But I ask you to keep in mind that there are thousands of cases like mine where families are driven apart and forced to be not to be unable to raise their child jointly successfully because of the current system. We cannot forget about all those folks as well too. So that would be my intro and my testify here. Smarter people who've dealt with this a longer amount of time who can tell you the technical reasons why we should do this.
All right, go right ahead. Welcome to the committee.
Yeah, so my name is Bill Doherty. I'm a professor at the University of Minnesota in the Department of Family Social Science. I've been a marriage and family therapist for over 40 years. I'm a researcher in divorce. I direct the Minnesota Couples on the Brink Project. I'm a champion of marriage, and when marriage is going to end, I'm a champion of the idea that it should end constructively for the people involved, including their children. This bill is going to update family law for the 21st century. What it does is it creates an option for people to divorce outside of any court system with no judge signing off. The current system stays in place for those who want it. And I'm here to say that cooperative private divorce, this bill is good for families. Our current court-based divorce law is a leftover from the days when people could only divorce when they could prove that their spouse violated the norms of marriage. At the beginning of our state, by the way, you had to pass a bill in the legislature to get divorced. And then it was assigned to the courts. But the notion was somebody screwed up, somebody was wrong, somebody was at fault, and so you needed a court, you needed a judge to determine fault. But when we introduced no-fault divorce in the 1970s, no one realized at that time that the court was no longer needed to grant a divorce if couples could agree on terms. because there was no fault to be determined. The downside to putting all divorces in the hands of the court is that the court system is designed for adversaries, not cooperators. So the logic here is that when people can come to an agreement on their own, they don't need to be in the court system with all of the adversarial process baked in. It's the essence of this. So creating the option of a no-court divorce will reduce conflict because of a basic psychological principle that people are more likely to abide by agreements they come to on their own, as opposed to having lawyers or others predict what a judge would ultimately decide. And reducing conflict between parents is the single most important thing we can do to help children after a divorce. This bill will also encourage the use of alternative, more supportive forms of assistance, including mediation, collaborative law, parenting help, and financial advice, as opposed to the current assumption that you should hire a lawyer the first time somebody brings up the idea of divorce. Now, of course, the current system allows for pro se and other forms of mutually agreed upon settlements by divorcing couples. So why create an option where there is no court involved at all? Because the problem is that the long shadow of the adversarial court system looms over conversations about voluntary agreements. Couples have to deal with what a judge will ultimately think is acceptable. And by the way, the judge will only think as acceptable agreements that cover everything for the life of the, as long as the child is a minor. So the judges will sign off when every line is, every T is crossed, every I is dotted. And not all couples need to make, as you said, Representative, your child was 2. You didn't have to come up with a 16-year agreement, but in the current system, if a judge is going to sign off, that's what you're going to have to do. Lawyers then become experts at telling their clients what will pass muster with a judge, as opposed to what will pass muster with you two. In other words, the final step of a judge's signature can influence every step in the current divorce process. The analogy would be if you were going to do something for your health, and ultimately a doctor had to sign off on that, then what the doctor would finally agree to would color everything in your conversations about health. That would be the analogy here. We've moved a lot of health care outside of the doctor's office. There's so many drugs that you can get now without a prescription that you had to go to the doctor for before, and some others that are more dangerous you have to go to the doctor for. That's an analogy to what we're doing here. You should only have to use the court when you cannot agree on things. I'd also like to address the understandable concern that this way of getting divorce outside of the court will encourage more divorces or will communicate a cultural message that divorce is not a serious matter. I'm going to make 3 brief points on this, and then I'm going to finish up. First, cooperative private divorce has a waiting period, a cooling off period that's not part of current law. My own research has shown that a meaningful subset of divorcing people are ambivalent about whether to proceed with a divorce to try to save their marriage. My Minnesota Couples of the Brink project is set up to help those people decide whether to proceed with the divorce or to work on their marriage. A waiting period can slow them down enough to discern their best solution. And the Bureau of Mediation Services, which would implement this process, will provide information on resources for couples who want to reconsider whether they're going to get divorced. Second, instructions for couples entering the cooperative private divorce process will come with a warning about the effects of divorce on children. It says, and this will be, it's in the bill and this will be in the instructions, many research studies have shown that divorce can have an adverse effect on children. This kind of statement is not found anywhere else in current law. Third, and related to my last point, the bill acknowledges the value of preventing unnecessary divorces. The first principle written into the bill and included in the instructions for couples urges them, quote, to reach a mutual decision to initiate divorce only after exhausting other options to solve your problems within the marriage, particularly if you have children. This is the first time in Minnesota law, or I suspect law in any state, that there will be an acknowledgement that divorce should be a last resort. In conclusion, this is a family-friendly bill that updates divorce law for the 21st century, where it is no longer necessary for a judge to review every agreement. It will help couples divorce better by putting all decisions in their own hands. The bill also articulates a marriage-supportive set of values in an era when we need to do marriage better and, when necessary, do divorce better so that people can heal and move on with their lives. Thank you, Madam Chair.
Thank you, Mr. Doherty. I know we have questions, but I think what I'd prefer to do is have all the testifiers first. So if you're able to stick around, that would be great. Chair Lesch, do you have another testifier here? I believe Ms. Vicki Hill-Ricky?
Yes, Madam Chair, thank you.
Okay. Welcome to the committee. Please introduce yourself, and you can begin.
Thank you, Madam Chairman and representatives. My name is Vicki Hill-Ricky. It rhymes. I am a retired nurse anesthetist. I am not used to speaking in front of people. I do have a story to tell. It's only 2 minutes long, and I appreciate your time. In 2009, I hired a family law attorney. 1 year and $60,000 later, I concluded I was unable to compete with my husband's ability to finance attorneys. It is a common misconception that you need to hire an attorney for negotiations during a divorce. The current system is set up to promote once loving partners to become adversaries. Lawyers tell us that we are in a contest. Who is going to win? And at what cost to us, and at what cost to our children? In our case, we had a 9-year-old child involved, and she had some learning disabilities, and so that made everything even more poignant. My decision to drop out of the lawyer versus lawyer traditional divorce process included the following benefits from mediation. First, I felt in mediation I had control over the divorce process, i.e. my life. I had control over my life. Secondly, improved communication between my spouse to settle our divorce with a win-win outcome. The competition ceased. Third, mediation involves a collaborative decision-making process. I felt learning how to collaborate with my spouse created a framework for post-divorce decision-making. Other benefits of mediation I experienced included mediation provided peaceful, respected negotiation, fair and equitable negotiations, fair because they are reached and agreed upon by both partners. Mediation is less expensive. 2 years of mediation cost us $10,000. Compared to 1 year of lawyer-driven negotiation cost me $60,000. Mediation is dignified. It is a kinder, more human process. Mediation is private and confidential. In litigated divorces, everything submitted to family court law is part of the public record, whereas mediation sessions are private and confidential. Mediation is faster. The pace of the process is controlled by the parties instead of being at the mercy of a lawyer or a judge's schedule. In conclusion, I was fortunate to learn about mediation from a friend. I was referred to Erickson Mediation Services. My spouse and I were able to resolve our differences. Now, 10 years later, we are able to maintain an amicable relationship. I thank Erickson Mediation for teaching us the skill of collaboration for the sake of our family's future. Thank you.
Thank you so much. We appreciate you being here today.
Thank you. Thank you.
So, Chair Lesch, it's my understanding you have one more proponent, but they've asked to speak after someone else, and I think that's fine because we're going to take all the testimony anyway and then open it up for questions. So at this point, if Mr. Dittburner is here, please go ahead and come forward. Looks like he's in the back there.
We'll take this out of his time.
You're sitting so far away, Mr. Ditburner. All right, welcome to the committee. Please introduce yourself and you can begin.
Thank you, Madam Chair, members of the committee. My name is Michael Ditburner. I am the legislative chair of the American Academy of Matrimonial Lawyers, Minnesota chapter. Also, I'm speaking on behalf of the family law section of the Minnesota State Bar Association. We oppose this legislation, and I first want to talk a little bit about our perspective regarding the so-called traditional family court system and its adversarial nature. I've been practicing for 35 years. I've seen the changes over the years, the increased amount of emphasis on alternative dispute resolution. People in my organization serve as mediators and alternative dispute resolution providers. Most family law attorneys I know hate trials. They see the impact that it has on their clients. Even if their client is successful on most of the issues, it's still a rather unpleasant experience for them. And it's unpleasant for them. It's not pleasant for us either, because we can see the pain that they have and the upset they have, even if they are mostly successful. The simple fact of the matter is that in today's day and age, vast majority of divorces, neither party are represented by counsel. And then in a lot of cases, only one person is represented by an attorney. So even if they have an attorney and one representing one of them. A lot of these uncontested cases don't even require a court appearance. And the fact is that people that are going through a divorce will submit an agreement to the court. It's a DIY divorce, do it yourself, and then the court will look at it and decide whether or not to approve it, which they do in the vast majority of the cases. It's been our experience that the court system in and of itself is not what makes people adversarial with each other. What makes people adversarial are things like domestic violence, substance abuse issues, personality disorders, cluster B personality disorders such as narcissism, borderline, histrionic, antisocial, paranoid, which are marked by a lack of self-awareness and lack of empathy, dishonesty, and then interference by family members, friends, and other people in that person's relationship or divorce. No one is otherwise inclined to, who is otherwise inclined to enter into an agreement fails to enter into agreement simply because they are going to be submitting the agreement to a judge for approval. Next, I want to talk about judicial approval and oversight and what it means and why we would like to have that. Agreements are only rejected by judges, by and large, in a small minority of cases where they are either egregiously unfair or are so poorly drafted that they will lead to confusion and litigation if someone seeks to enforce them later. These egregiously unfair agreements are like one-sided agreements, and I'll give you some examples. An agreement where 100% of the marital assets are awarded to one party. An agreement that has no parenting time for one parent unless a psychologist chosen by the custodial parent approves. An agreement where no child support at all or expense sharing at all occurs, even though one parent makes minimum wage and the other parent has a six-figure income. Examples of poorly drafted agreements: people divide assets without stating how it's supposed to be divided. They share expenses without specifying as to what those expenses are and without specifying how they should be shared. They share parenting time without providing a schedule. They state that somebody will pay 50% of their income, but they don't say whether it's a gross or a net figure. Why do we want judges to reject one-sided or poorly drafted agreements? Well, one-sided agreements are often caused by a power imbalance that we want judges to address. Could be domestic violence or coercive control. It doesn't even have to be domestic violence. It could be somebody's being blackmailed. I represented a client in a situation where they were asked to give up sole legal custody or their spouse was going to file a complaint against them with their professional licensing board. That's an example of a power imbalance. I was involved in another case where somebody had remorse over something they did during their marriage, and the other spouse took advantage of that remorse by insisting that they be awarded custody, that the other parent's parenting time be restricted, and that they get most of the assets. That's another power imbalance. In our opinion, cooperative private divorce is going to be a magnet for a dominant spouse in a power imbalanced relationship because it's private and because there is no judicial oversight. I don't think there's even much oversight by the Bureau of Mediation Services as this is envisioned. People that have testified or people that support this bill that are in the ADR community, they're not probably going to be the primary providers of assistance to people that are going through a private cooperative divorce. I think what's likely to happen is going to be internet-based companies with a high volume, low overhead operation which have banner ads on websites who will do it on the cheap with no consultation and little advice. Because why meet with a mediator in person when somebody can do it on the cheap for you at a much lower price? And I've taken a look at the form. They do have a template that people are supposed to use for the declaration of divorce, but it's not required to use that template as far as I can see. I'm assuming that you could just stamp the words declaration of divorce on something and then submit it to the Bureau of Mediation Services. If that's not good enough, then of course, then the Bureau of Mediation Services would be involved in basically taking on a judicial role. Some people who are self-represented, they submit it to the court. They're going to be the same ones that probably use this type of thing, this type of action. And people, instead will be not seeking any kind of legal representation, or they could seek legal representation. But I'll tell you the one time when they will be hiring lawyers, and the one time it will become very adversarial, that's when a one-sided agreement or a poorly drafted agreement is sought to be enforced, vacated, or modified in the district court. And I think that's why a lot of judicial officers and others oppose this legislation, because they see the likelihood of abuse and the likelihood that there is going to be huge problems on the back end because things weren't taken care of the front end. By and large, it doesn't affect family law attorneys at all. Because the same people that are unrepresented by counsel who seek to have agreements approved in district court are probably going to be the people that tend to go through private cooperative divorce. I have nothing further. Thank you.
Thank you so much, Mr. Dittberner. Let's see, I believe Judge Peterson is here speaking in support of the bill. So welcome, Judge. Go ahead and introduce yourself, and you can begin.
Yes, thank you for allowing me to speak today. My name is Bruce Peterson. I'm a judge in Hennepin County. I've been a judge coming up next month in 20 years, 7 of those handling exclusively family court cases, and 2 years as presiding judge of our family court. And I'd like to give you some perspective, my perspective, on some of the issues you've heard about here today. First of all, I speak totally for myself, not on behalf of the judicial branch. And I want to emphasize that there have been remarkable improvements. Mr. Dittberner, who always has interesting things to say, recognizes that the courts have worked very hard to improve the divorce process, to give more power to people, to encourage the resolution of divorces out of court. Things like early neutral evaluations and moderated settlement agreements have been very effective. The interesting thing is they do exactly what this bill seeks to do, which is to empower participants and move the cases out of court. The problem is they are hampered by this basic problem that Dr. Doherty was talking about, which is the shadow of the court system falls over the way people engage in these processes. What is the judge going to do? Can I do better with the judge than I can with talking to my partner? Mr. Dittberner mentioned do-it-yourself divorce, the most popular means for citizens, unrepresented many of them, to resolve their cases now is a process called the joint petition for dissolution. It's very similar to what this bill would propose in that it's an online system where parties record their agreements, they're given instructions on how to do it, it's the computer prompts with questions and winds up filling out a form that's filed with the court. The instructions are very detailed and helpful. Do this, fill this out, sign this, pay this fee, file this here. And the last instruction is wait. Wait. You are not divorced until the judge signs the decree and the court administrator enters the decree. Wait to receive a notice from the court telling you that you are divorced. The judge will decide if a court hearing is necessary. So you're not really in control of your own family situation. What you're doing is trying to make sure that you're doing something ultimately a judge will approve. And that's what casts the shadow of animosity and hostility over the court system, over the divorce system. Mr. Didburner spent a fair amount of time talking about a very serious issue, which is mistakes and undue pressure and power imbalances. I'm very concerned about that. We should all be concerned about that. I think this bill does a very good job of addressing that problem. There's a screening tool right in the bill that people go through. If you're being pressured or intimidated, don't do this. Don't engage in this process if you feel you can't trust your partner to work out agreements in the best for everybody. Will there be people who that doesn't, they're pressured into doing this anyway? The answer is yes. My question is, there are people right now where that happens. If someone is seriously coerced, they will say things or write or sign things in court that a judge won't catch. Now, the reason you have hard jobs and public policy is hard because nothing's perfect. It's always trade-offs. In my view, the few additional cases of unfairness that might happen with this system, in spite of the warnings and screenings, are outweighed by my experience seeing the emotional toll on families and damage to children done by a system that encourages people to become adversaries and enemies of each other. It's just baked into the system. And that's why the movements to improve divorce all over are to try to get it out of court. In fact, the European countries are moving this way. Norway, Denmark, France, Portugal have administrative divorce processes now. They've recognized that that final hurdle of judicial approval does more damage than it prevents. And I'll stop at that point and be glad to answer any questions.
Thank you so much, Your Honor. I don't believe anybody else has signed up to testify at this point, so why don't we go ahead and take questions from members? And I think Representative Herm, you had the first question.
Thank you, Madam Chair. Representative Lesch, just a quick question. And maybe this isn't the place to have this discussion. You can just let me know that too if that's the case. But is there recourse for, let's say you go through this process, it works out well, and then I really support this because I think this is a good addition to what we can do right now. But if it turns out that the parties don't agree to what they initially said as they went through this process, is there recourse for the individuals involved to be able to address that or hold the person accountable or change direction as to the agreements that were made during this time period?
There's a judge sitting next to me. I should probably answer that. But the short answer is yes, absolutely, and it's the same recourse that occurs in the existing family court system to establish a change in circumstances. But why don't I have Judge Peterson speak to it?
Go ahead, Judge.
We live in this mentality of the current system where people are adversaries and they're going to fight and they're not going to want to do what they're obligated to do. Things change. if you start with a system that encourages people and empowers them to collaborate together, as life changes and maybe somebody loses a job and can't pay that child support or whatever, you'd think the parties who are used to resolving, collaborating will be able to do that. That's not always going to happen. Sometimes people are going to fall down on their agreements, and it's not going to be for a good reason. And this bill provides a very simple process for petitioning the court for enforcing or vacating or modifying an agreement.
Representative Herr?
That's perfect. Thank you, Madam
Okay.
Chair.
Chair Scott?
Thank you, Madam Chair, and good to see you, Judge Peterson.
Thank you
for being here.
Representative Scott.
And you mentioned what's going on in some of these other countries in Europe, Denmark, and so forth. And I don't know how long they've been doing these things administratively, but can you speak to the divorce rates there? Have they gone up, down, stayed the same? If you know the answer to that question.
Go ahead, Judge.
No, I'm not able to. I know France's procedure is relatively new, and I doubt they have any details. I know that the Scandinavian countries have a different, I can't answer the question.
It looks like Mr. Doherty may have an answer to that if you want to come back to the table.
You come back
There's-
here after I-
Yeah, and there's a couple chairs there.
So,
You can each sit there if you want. There you go.
Okay. Okay.
Yep, great. Go ahead, Mr. Doherty.
So, yes, Madam Chair, Representative Scott, divorce rates have been going down across the developed world. So there hasn't been some sort of uptick when these new procedures go in.
Thank you, Madam
Chair
Chair.
Scott?
Thank you. And there are several things about this bill that I do like, and one of them is the waiting period. And several years ago, I dropped a bill that would require, I think it was, I don't know if it was a 1-year waiting period, or I don't remember what it was. But I think that's a really good thing because, and maybe Professor Doherty, you can speak to this, but aren't there surveys that are done post-divorce, a few years after the fact, and a lot of people respond by saying that they wish they would have waited. They felt like they rushed into it in hindsight, and that they kind of regret that, that they didn't work harder at their marriage and saving their marriage. And if you could speak to any of the data out there that's on that, that'd be great.
Mr. Doherty.
Yes, thank you, Madam Chair. Yes, there has been a lot of surveys. There's been new research that I and other colleagues have done. Upwards of 40% of people express regrets looking back that they got the divorce. And waiting periods, the research is tricky on this, okay? So there's nothing definitive. But waiting periods do seem to have a small positive effect. And anecdotally, we know that some marriages end because somebody falls in love with somebody else, and within a few months, that person says, "I don't like you anymore." But they've already gotten the divorce. So the waiting period, we're not saying it's a panacea, but it's a useful thing, and most states do have one. Minnesota's never had one.
Yeah.
Chair Scott.
Thank you, Madam Chair. And, I've heard a statistic bantied about since I've been here, and that's that folks in the family law community will say that 90 to 95% of cases settle outside of before they get to an actual hearing. And I've always maintained that that's because the deck is stacked against one party, and that's usually the dad, because they have heard so many horror stories. And again, this goes to your point about attorneys saying, well, this is what's going to be acceptable to the judge, right? So it goes to that point as well. But I think that this, and I'm not saying I'm not endorsing this, but I think that it would go a long way for couples to actually have the ability to settle these things outside of court, because they know going into court is going to have that result that they may not like. And so I don't know if either one of you want to speak to that, if I'm making myself clear or not, but.
Yeah,
Go ahead, Judge.
Representative Scott, I know from our long history that you care very deeply about parents and families. And I got interested in this bill because I thought it would help families and reduce divorce rates and make for fair agreements. I think the concept of when your marriage is in trouble, going to a lawyer as your first stop is exactly the wrong thing to do. I think now Mr. Dittberner predicts there will be cheap internet services, and of course there will be. But there will also be people like Erickson Mediation who develop processes, family resource and recovery services that people seek out when their marriage is in trouble, of which counseling might be one avenue, a trial separation, a substance abuse program. There might be, waiting might make more sense than going to a lawyer and working on that right away. You know, as far as people viewing their agreements right now are crafted and hammered out based upon what we're going to get from the judge. I got disillusioned with the early neutral evaluation process when I realized what the evaluators were telling the parents about the parenting they should engage in wasn't what was best for the children, but what a judge would be likely to approve. So it's this, Bill described it, it's this shadow of the court system that is, it's inevitable if you have that kind of a system.
Thank you, Madam Chair, and thanks for the latitude. I'll just thank you for answering those questions. And I'm not sure that I can fully, like I said, I'm not sure I can fully support this, but I think there's a lot of merit to what is being said here and what is being offered. And I just do want to add, too, that I think you're definitely going down the right road with mediation. And I think mediation is, I mean, you heard the testimony of how much money can be saved, and people that are involved in mediation, as a general rule, and I don't know if there's statistics out there on this or not, but they generally are more pleased with the outcomes. Both parties are generally more pleased with the outcome after having gone through mediation.
Mediation will be more client-centered if it's not directed towards what are you going to get from a judge, if it's directed towards what's best for our family and what can we agree on together.
Thank you. I think Chair Liebling, you had a question.
Yes, thank you, Madam Chair, and thank you to the testifiers. I find this very intriguing, but I do have a few concerns. One is about the, well, for example, as I'm reading through the bill on line 3.16, it talks about agreements that allocate expenses for child or children is an enforceable contract. You know, when we think about the potential power imbalances and all that you've addressed very well, I guess the question I have is if you end up having to go to court, why should this be an enforceable agreement? Why should you not be starting over with the idea that there's some reason that this thing failed and there might be a power imbalance behind it? So it concerns me a little bit that if you make this agreement initially and everybody tries to be in good faith, but in fact there is something going on there, then you go to court and you've got a document where there's something that could be held against you. I think that somewhat works against the premise of the bill.
I don't know who wants to take that, Judge. Do you want to answer that? Go ahead.
I'll tell you honestly, Representative Liebling, what I would do if I were received one of these motions to enforce or vacate or modify child support, I would establish child support in the first instance and apply the guidelines. I think judges are so used to using the guidelines, and I think that if the parties' agreement breaks down and they're not able to follow through on it, what will happen is someone will go to court and say, I'm seeking enforcement of this agreement, and the judge will say, well, we're going to apply the guidelines then.
I think Mr. Detburner wanted to respond to that question too. So if you could go ahead and come down.
And if I could, Madam Chair, just while he's coming down.
Sure, go right ahead.
You know, that may be the way some judges would do it, but that's not what the bill says. So that's my concern. But I'm happy to hear from Mr. Detburner.
Great. Go ahead, Mr. Detburner. Would you get in front of the microphone a little bit, please, so we can make sure we can
Madam Chair, Representative Liebling, I'll also point out, too, that in addition to do we establish it anew, do we modify it, those types of questions that a judge is going to have naturally, there's also the question, what about the party who did not receive any of that expense payment from the other party, comes into court and says, well, you know, for the past 5 years, I've been forced to pay all the expenses because they've not been paying anything. And so I have all these receipts for clothing, for this, for that. Please award me a judgment for child support arrearages or for expense arrearages or whatever. How would a judge deal with that? How would the attorneys deal with that? It's a big fat mess. And that's the type of thing that a judge in the court system, if they're presented with an agreement like that, is going to question the parties at, perhaps at a hearing. He's going to say, what are you intending to do here? How are you trying to enforce this in the future? The judge is going to ask that question, but there's no judge in cooperative private divorce. There's nobody that is available to make sure that the parties don't have something that comes back to bite them. And so that's why the lack of judicial oversight and scrutiny is a problem. It's not going to be provided by the Bureau of Mediation Services. And I'll also tell you, too, for all the good work that these mediators can possibly do for these couples, my prediction is that they're not going to be involved in it. This internet company is going to basically take over the situation. They're going to stamp a headline that says Declaration of Divorce, and they're going to have a tiny little checklist. And they're going to outbid Erickson Mediation Institute and every other ADR provider that might be providing services to people in cooperative private divorce. And no kind of disclaimer is going to help. Because people are going to see that, they're going to move on. It's going to be a very ineffective screening device for power imbalances.
Chair Liebling.
Well, thank you, Madam Chair and Mr. Dittburner. I kind of think that, you know, if 95 or 90% of the people don't have to come back to court, and then that 10 or 5% do, and then the judge wants to go back and examine the whole thing, I would say that's appropriate. I would say at that point, you're starting out, and there should be a full examination, because that's how perhaps we would have the backstop for the ones where it really shouldn't have been, or there was some other thing going on. So, you know, I guess that doesn't bother me so much. I did have one other question, Madam Chair, if I might. It's kind of a quick one for the advocates. This is all in English in the bill, and I'm wondering if there would be a provision, maybe I missed it here, that this would be in other languages as well, because as we know, we have a sizable portion of our population that English is not their first language, and of course, understanding what you're doing is going to be really critical here.
Absolutely necessary, yes.
Agreed.
Let's see, Representative Carlson.
Thank you, Madam Chair. So kind of continuing along the same line of questioning so far, I'm a little, I mean, again, I'm, you know, very appreciative of what the intent and what we're trying to do here, but I'm a little concerned about how this has been represented so far as a very simple approach, easy procedure. And as I read through the bill, I mean, this is serious stuff. It's extremely sobering reading through the bill where, you know, there are headers that cause you to pause due to language such as caution, laying out some very sobering facts for those that are considering this option to cause and reflect on what exactly they're doing. And that's a good thing, because marriage is a contract, and you're now breaking that contract, and there's significant consequences as a part of that. But I can see as a couple would go through this, and then just continuing on to page 10, under the heading caution on line 10.5, it enumerates, and there's earlier two enumerations under the agreement. Starting from there, we agree on the following plan to provide health insurance. We agree for the payment to pay off our debts. We agree to follow a plan for dividing our property and assets, real estate agreements, and refinancing. All these things that bind a couple together are enumerated here for consideration. So to my question then to the subject matter experts, what's your take in terms of if someone truly reads through this, you know, if it's being presented as a simpler option where this is, in my opinion, really getting at all that needs to be considered, to where someone's going to say, holy cow, I need some help. I need some assistance. I need an attorney. Where in the process do the mediators then, you know, instead of when they see that kind of self-doubt in pursuing this, where they can get the assistance to direct them towards the existing process? Is there something in here that takes them off of this track and perhaps makes them aware of what their other options are?
I don't know who wants to answer
Well,
that.
I guess,
Go ahead,
so,
Lesch.
thank you, Madam Chair, and Representative Carlson. I take some exception to the suggestion that this has been presented as simple and easy process. Keep in mind that simple and easy are two very very different things.
I'm using them as separate words, yeah.
Okay, good. Because, when I went in the Army, they said it's simple. Just, show up at the right time in the right uniform at the right place and follow orders. That's simple. It wasn't always easy. And this, we are trying to make it easier for individuals. But I will tell you that I get calls on a weekly basis from folks who need help with something that is simple, an internet search. Here's my situation, here's my position, I want to initiate, I've received papers. That help is available everywhere you look because there are attorneys willing to take retainers for that. But did you want to speak to this, Judge Peterson?
Well, I think the list is, the list of issues is there to trigger, these are the things that most divorce agreements have to include. And repeatedly there are statements, if you don't know what to do here, get some help. As Dr. Doherty mentioned, one of the things about a court divorce is everything has to be done at once. I have signed divorce decrees that were 30 pages that included several dozen different issues that I've been married 30 years. My wife and I couldn't agree on those many issues. The parties, they want to be divorced, they can get divorced, they can solve the things they want to solve now, they can reserve some things for later, they can get some help now, they can put off dealing with who's going to have the cabin on odd weekends if they don't need to resolve that now. It's a process rather than a one-time snapshot of the next 30 years.
Representative Carlson.
Thank you for that. So to follow up then, if those issues are not resolved, how do you get to the declaration of divorce then?
Go ahead, Judge.
Once you submit it, once you have an agreement that you want to be divorced, and here's the agreements we have, you can submit a declaration of divorce.
Representative Carlson.
Thank you, Madam Chair. So to that point, you could have unresolved issues but still receive a declaration of divorce?
Yes.
Can I get your thoughts on that? Or what would be the reason for why there would be this document declaring some kind of closure, but yet there is none?
Well,
Chair Lesch.
Madam Chair and Representative Carlson, I mean, that occurs in divorces today. Okay. There are existing unresolved issues, some intentionally unresolved because neither party necessarily knows what they want to do. I mean, one guy last year who knew exactly what school he wanted the kid to go to. The kid was 2 years old. And mom was like, well, I'm not so sure about that. It's a little bit closer to the house. And he's like, well, it's got to be in there. I don't like the school that's closer. They do a terrible job. And at the end of the day, in the interest of resolving it, that issue was left out in the interest of getting a resolution so that they would have to agree on it later. As you know, any lawyer in here knows that an agreement to agree later is no agreement. And sometimes they have to be left unresolved.
Representative Carlson.
Thank you, Madam Chair. Chairman Lesch, then, so that's an important piece to whereas families continue on with time and newer things come up, I understand. But what about fundamental issues like alimony payments and parenting plans? Can you have a declaration of divorce without those two critical elements being agreed upon?
Well, I mean, again, I don't think that, well, why don't I have the judge or professor speak to that?
Make no mistake about it. This bill is it's a non-paternalistic bill. It operates under the assumption that people control their lives in every other respect. They make decisions about houses who to marry, houses to buy, having children, education. That most people, when they're empowered, will act responsibly. And most of what the concerns that come up with this are we have to be paternalistic towards people that won't do a good job, won't take it seriously, there'll be power imbalances. This bill fully instructs somebody how to do a divorce if they want to do it responsibly. If they want to get a divorce without resolving important issues, they'll have to live with the consequences.
Can we wrap it up here?
Yes, real quick.
Okay.
Thank you, Madam Chair. And Judge Peterson, I appreciate that, but I'm also responsible for those that can be abused by such an approach too. And I can't just disregard that, whether it be 5% or 1% or 0.11%. That I need to make sure that those people are protected too.
So if I could just add something briefly. The medical field goes through this all the time. That it used to be to get hydrochloroquine for a rash, you had to go to a doctor, because it's possible for some people to overuse the medicine and then they get really bad skin conditions. And there's a trade-off. And ultimately, you have to decide whether it's best for people involved, for the society. We haven't even mentioned the cost of the courts to society. So appreciate what you're saying, and it's the trade-off.
Yeah, and again, it's been a good conversation.
Yep.
Yeah.
I actually have a question too about the power dynamics here, and I'm concerned that the words, just the caution isn't really enough, especially for those relationships for battered women. And I think I'm going to put someone on the spot here. I see Mr. Carlson in the audience, and I know that he represents the Minnesota Coalition for Battered Women, and I am curious if anyone's talked to them about their position on this bill. So, Mr. Carlson, if you wouldn't mind coming forward. Sorry to put you on the spot, Mr. Carlson, but we've done that before in this committee. I know you're used to it.
One of the problems of being a frequent flyer in this committee is sometimes you get asked questions, and I know I have the right to remain silent.
Please go ahead and introduce yourself. You know the drill.
Joel Carlson, I own a legal research government affairs business here in St. Paul, and I have long represented the Minnesota Coalition for Battered Women, and we do have serious concerns about this bill, and I've spent quality time with Judge Peterson over the years. I have no doubt about his earnest approach to this, and I have great respect for him. And our executive director, Liz Richards, couldn't be here today, and I know she and Professor Doherty have gone round and round on this particular issue. Our concern about this bill is really centered on the fact that domestic abuse is not always about a black eye and a broken arm. It is often a system of power and control, and it only becomes violent when you don't act in the way that your abuser wants you to act. That's when the violence occurs. If you're doing what you're told, everything is fine. It's when you step out of what you're expected to do that violence occurs. And we know for a fact that one of the most lethal times for women is when they are separating. We've documented over 1,000 cases of domestic homicide in Minnesota through the femicide report in the last 30 years. We've had 2 just linked to divorce just in the last 3 months. So this is a very dangerous time, and so we do have concerns about this bill. And I want to tell you, members, in all honesty, if you look at the coercion screening tool on page 13, I have met with dozens of battered women that would read every single word of that and maybe agree that every single one of them has occurred. The threat of violence, the intimidation, not discussing this with anyone else. All of those may have occurred, and they would still agree to this process if that's what the abuser wants, because that's how you're going to stop the abuse. That is the problem with this tool, and so we do have great concerns about the bill, and I have great respect for everybody on this committee and Chairman Lesch in particular, but this one is a bridge too far.
Chair Lesch, would you like to respond to that?
I would. Thank you, Madam Chair and members. What you just heard and what you heard from Mr. Dittbrenner earlier, I'd like you to keep this in perspective, okay? The narrative that has been painted is of a bloviating, overbearing, belligerent man, which there are out there, and a compliant, submissive, meek woman. And that a process like this would further endanger the latter. Members, keep in mind, there is no process that we can enact that would fully protect the latter party. None. Because if that is true, then that latter party would submit to anything, would stay married at the behest of the abuser, would agree to any terms at the behest of the abuser, Simply offering the opportunity for a couple going through a very difficult time to do so voluntarily should not be held hostage for that percentage of situations of which the only thing we can do around here is maintain a higher state of public safety vigilance, is to support those domestic abuse bills that I and others here have consistently supported going through the legislature. But holding hostage all those other couples who simply want to reduce the conflict so they can co-parent their kid for the next 15 years, that's not a good enough reason. And I understand the passions run high about this. But I would also ask you to remember that the family section of the bar and the domestic violence community has opposed every single family reform bill we've taken up since I've been here, and that's 17 years. Every single one. And they do so with honesty, and they do so with integrity, and they do so with the strong belief that those reform measures would be bad for women who are victims of violence. But I think our track record has shown that it has not turned in to that hobgoblin of violence. I think that those things have done some good for families who just want to honestly go through this and move on. And I ask you to keep in mind that this process is voluntary. That would be my only response.
Thank you, Mr. Chair. And so members, what I'd like to do here, we have about 10 minutes left. I have 4 of you who have questions. I haven't opened it up to the audience yet to see if anybody else from the audience wanted to testify. So I would like to do that first. Does anyone here from the audience wish to testify? Okay, I'm not seeing that. So let's go with, I think, Chair Considine, you had a question.
Thank you, Madam Chair. Thank you, Chair Lesch, for bringing this forward. I'm just going back to my personal experience. I had 2 friends, 2 couples that we knew got divorced, both remarkably similar. There was no accusations of abuse. There was no, they just both didn't get along. They found that they had fundamental differences in philosophy as they were moving forward. Dave went to the county library, downloaded the forms for dissolution. It was not easy. He and his wife sat there for a couple of months, but hammered it out. They were done in about 2 months. Total cost, $99 for court fees. They get along reasonably well to this day. The other couple did have a real estate thing where they felt like they needed to go. It took them 2 years and $40,000 to get it, and at the end of it, we're not speaking. Where at the beginning they had been doing really well, and it took a long time for them to even talk again because it got so adversarial once it was brought forward. So I think this is a great idea, and I guess I just would say that there's nothing in this bill that prohibits somebody from going to an attorney and going that route if they feel, in the case of abuse or something. That's correct, Chairman Lesch?
It's, Madam Chair and Chair Considine, that's correct.
Let's see. Chair Scott.
Oh, thank you, Madam Chair. And, you know, the parenting classes that are required in this bill, are those going to be any different than what people take? I know I had a bill last night that was heard for people that have not reached an agreement outside of court that they take these parenting classes. And so are those the same parenting classes, same kind of content to one of the professors?
Representative Scott, yes, those are the same classes.
Thank you. And Madam Chair, so why couldn't, and I've sat through one session of what kind of the parenting classes are like, and it's really important to note that parents meet separately. They're not in the same room when they have these parenting classes. They meet separately. So, and I had the opportunity down at North Point to sit through one of those parenting classes with some of the moms. And so my question is, do those parenting classes now have material in them that address if you are being abused, if you are being coerced, if you feel you're in danger, go immediately and get help? Is that part of those parenting classes at all?
Professor?
Madam Chairman, Representative Scott, I believe so. I'm not positive. There's a list of topics to be covered, and I believe that's in there, but I'm not positive.
Madam Chair, thank you. And I think that should be part of it, especially if this would ever become law. I think that has to be part of those parenting classes so that if someone's in the middle of abuse, that they have they can feel empowered and know that they need to get that help. And that usually the facilitator would be a person that they could go to say, I'm feeling this, what do I do? The other comment that I wanted to make, and I am not in any way belittling that times of divorce and separation are really highly dangerous for women, or can be. But I also want to point out that dads that have never, ever had any accusations of abuse ever, this is a dangerous time for them too, because that's when false allegations get charged up against them. And so if this can happen outside of court where that stuff doesn't have to be drummed up and then figured out as who's telling the truth here, so I think in that regard it would be a good thing.
Thank you, Chair Scott. Let's see, Representative Herr.
Thank you, Madam Chair. Chair Lesch, I agreed with everything you said in that, a protection and what this does and what it doesn't do, so I really appreciate that comment. I do just want to maybe shift this conversation a little bit away from that we're just looking at this from the perspective of battered women, because in our society, right, we live in a patriarchal society in which there are power dynamics between men and women, or the person who has more capital, right, social capital. And so this will, and I think that it's interesting that when other women find out that I pay the bills, I plan for our future, I put away the money for our savings and 401k, a lot of women still are, they don't know those types of things. And I do worry that the person who has the greater power dynamics in a relationship, whether it's the man or the woman, will have the advantage in some of these, in this type of agreement in which they get to sort of set the stage. And if they can do it in a really nice way, the person who doesn't know to ask the questions they need to ask will come out adversely from these situations. And so power dynamics, whether somebody's battered or not, plays into this. But you are correct that this doesn't address those things, and it can't, and that the option for people to have a private divorce, I think, is a good option, and I would support the bill. But I just wanted to make sure that people understand that intent of what we're trying to do, and really the systemic problems within our own society around power and gender and power dynamics, that those things are real, and that we do have to take those things into consideration and how the outcome affects people when we do something like this. So,
Thank you.
Did you have a response to that? Chair?
No, just, I agree, Madam Chair, Representative Herr, I agree. Although ironically, sometimes I have seen someone with the greater power dynamic specifically choose to forego any kind of ADR, alternative dispute resolution, and go the litigation route because it provides them an opportunity to extract more stress and worry out of the maybe beta individual, because it forces them to pay, and knows that they don't have the resources to pay the money for the lawyer, so they can work them over better in a litigation context and sling more mud than they can in ADR, and so they specifically choose the litigious route. But yes, I agree that exists in multiple contexts.
And I think we had one more question, Chair Liebling.
Thank you, Madam Chair. And we've talked about this a lot, the power dynamic. I appreciate Representative Herr's comment very much. I really didn't hear the answer. I would really like a commitment to take out the stuff that stops that makes there be a presumption when you get to court. If you do one of these things, and then for whatever reason, a year, 2 years later, you say, oh my God, he manipulated me into this. This is not good. This is not working. I want to go to court. There shouldn't be a presumption. You shouldn't be starting from this thing that you did under this statute. That's my concern, because of all these things we've been talking about with the power imbalance. So if that exists and the couple ends up, one or the other or both of them, ends up going to the court with a concern, there shouldn't be a presumption that whatever they agreed to under whatever conditions is going to be the starting point. That's the concern I have. Representative Lesch, can you
go ahead.
Talk to me about that? Can you fix that in a later stop?
So Madam Chair and Chair Liebling, you're talking about kind of a de novo review.
Yes.
Can I have 1 second, Madam Chair?
Go ahead.
Getting things done.
Okay. So here's my initial thoughts on that. So child support, de novo, we absolutely agree it should be de novo. If there's allegations of fraud or intimidation with respect to property division, that also should be de novo. Would that satisfy most of your concerns, Chair Liebling?
Well, Mr. Chair, I think so. I don't work in this area. I don't know, I can't off the top of my head say what all the issues would be, but if you say that you're going to work on that so that we don't have this, because I'm really concerned, as some of the other members are saying, that there could be a power imbalance. You know, sometimes people kind of get some support, come into their own later, and they go, oh my God, and I don't want this thing then to rule what happens when they go to the, and to get that help and go to a court and say, hey, I need to really make a change. That's my concern. And, you know, what you've said sounds good, but I don't want to say, well, that's all, because I can't do that right here and now. But if you can work on that with me and make sure that, you know, we give that protection to people. I want a backstop to this,
Sure.
where a court can look at it and say, whoa, this thing really wasn't right. Let's look at it de novo.
Sure, Madam Chair and Chair Liebling, I think that's fair, and you have my commitment to work on that with you.
Okay, so Mr. Detmer, we don't have time. I know you're raising your hand over there. This bill is intended to go to a next stop, so hopefully you can address that the next time it comes around. We're done with questions here. Chair Lesch, if you wanted to finish, recognizing that we are at time right now, if you had any closing comments.
Thank you. Just a closing comment. I reiterate, members, that this is voluntary. Divorcing couples do not have to go through this, but I'd ask you to take this into consideration, this story. One of the major issues that gave me pause when I went through my divorce is my wife's attorney was, I don't think, very fair in the process, and I don't think that's completely uncommon. And when she introduced another belligerent term that they were not going to agree to, and by the way, this was resolved out of court, just like all and before trial. So do not allow the suggestion that most of these divorces are resolved before trial suggest that this was in any way non-adversarial. This was horrible because it was all done under the specter of trial. And when this term was introduced or offer was made, I had a suggestion, not from my attorney, but from another family law attorney. You need to put your ex through the full battery of psychological testing to determine her fitness as a parent. And I thought, you've got to be kidding me. And I said to this attorney, you do not have to jointly raise this child for the next 15 years with her. I do. And I said, we're not doing that. And the response I got was, well, then I need to write a CYA letter protecting myself because this was the advice I gave you that you had to do in order to secure a position. It's my job as an attorney to represent you effectively. And I said, fine, write your CYA letter. That is the response many parents get from their attorneys because, like I said, when you grow up and you do this and you litigate it in this system, your only tool is a hammer and every problem looks like a nail, and you end up making it horrible for parents who want to jointly parent a child. And do not let anyone suggest that a sincere desire by parents to jointly raise a child or children or a family or even have a good relationship with their spouse after the divorce should be held hostage to specters of other things. So I ask that you give, I'm never going to get divorced again. I don't care what anyone says. It's not going to happen, okay? But anyone else who is, I ask that you let them have that opportunity. So I appreciate your support. Thank you.
All right, Chair Lesch moves his bill, House File 1115, to be recommended to be re-referred to the Ways and Means Committee. All those in favor say aye.
Aye.
All opposed say nay.
No.
Nay. The motion prevails, and House File 1115 will be re-referred to the Ways and Means Committee. Members, at this point, we are going to be in recess, and we'll reconvene in this room tonight at 7 p.m.